Mr. Olo or Dr. Olo? Mr. Cohen? Who does he appear for? Upon review of the evidence in possession of the prosecution, the prosecution counsel, Mr. Kinyanjui, relied on the provisions of Article 157 of the Constitution, Section 87A of the Criminal Procedure Code, and the decision to charge guidelines. None of the defense counsel on record opposed to the application to withdraw the charges against the aforementioned accused persons. The point for determination is whether the application made by the prosecution is merited, and that is whether there is good ground for withdrawal of the charges as against the aforementioned accused persons. The prosecution bears the burden. Of this case, a total of 13 witnesses have so far testified. The gist of the reason given by the prosecution is that upon review of the evidence in their possession, they do not consider it tenable to proceed with the charges against the aforementioned accused persons. The court is an impartial arbiter. It ought not refuse such an application where the party who has the burden of proving the charges has indicated doubt on his ability to discharge the burden of proving the charges based on the evidence in his possession, only part of which has so far been adduced in this trial. For these reasons, I find no reason to warrant denial of the application because the reasons given are good enough to support the said application. Excuse me. Therefore, the prosecution is permitted to withdraw the respective charges against the accused persons numbers 1, 9, 10, 12, 13, 14, 15, 16, 17, 19, 20, 21, and 22, and accordingly each of the said accused persons is discharged of each of the respective counts against him or her under Section 87A of the Criminal Procedure Code. Securities deposited, whether in the form of title documents or cash bail, to be released to the respective depositors thereof in respect of the discharged aforementioned accused persons only. With regard to the remaining accused persons, hearing dates shall remain as already allocated during the proceedings of 30th of January this year. Orders accordingly.
Well, most of that, Your Honor. Most of that, Your Honor.
Thank you.
Also, glad Your Honor, just as a part of the housekeeping business, Mr. Kinyanjui had indicated that there are 9 witnesses remaining. If he could kindly indicate the next witnesses lined up for the 22nd of April.
I pray for a copy of the typed ruling and the order of the court.
22nd, 23rd, and 22nd of May. I was wondering whether the issue that Mr. Kinyanjui raises can be taken up on the 22nd of April itself, so that the application that he is making, it would be important to be physically present in court. And I'm also aware that some of the remaining accused persons have been traveling from far within the country. And it would save on the court time, and it would be more convenient to counsel, the court, and even the parties remaining.
We can take a date as suggested by my learned colleague, Mr. Stiva, because we will strongly be opposing any amendment of the charges. Let my colleague be put on notice. Any amendment at this time will be opposed strongly.
We can deal with it maybe 30 minutes or 1 hour, and then depending on we seem to lost.
Someone was talking.
Your Honor, I believe amendment of charge sheet will take up to where parties are going to take plea again, and that cannot happen virtually. So I believe Shitiva's suggestion is quite okay, being that we also have to be considering that the parties have been carrying a lot of expenses.
Amendment is to change the numbering of accused persons. Yes.
Much obliged.